Welcome, everybody. Thank you for taking time out of your day to join us. My name is Amy Rizzo. I'm the marketing manager for Kelleher & Holland. Today's webinar topic is acquiring and protecting your financial services talent. There's been a lot of buzz surrounding the use of restrictive covenants recently, and our speakers today are well-versed in enforcement strategies and conflict resolution. So let's get started. First, a quick introduction to our firm. Kelleher & Holland is a full-service law firm comprising over 50 teammates with 3 Chicagoland locations, plus an office in Naples, Florida. Our attorneys are licensed in multiple states throughout the country, giving us a national presence, and our affiliation with Mackerel International Legal Network gives us a global presence as well. We provide 360 degrees of personal and business services, and that means we are your one-stop legal solution provider. Now I'd like to introduce our presenters today. First is Andrew Bowling. He has an impressive award-winning career spanning over 35 years in the employment, counseling, and corporate compliance areas of the law. Andy counsels clients on all phases of the employment cycle, from hiring to leave management, and has handled large-scale reductions in force and high-profile employee separations. Also speaking today on the litigation side is Michael Lee, our resident FINRA Dispute Resolution Services Arbitrator. Mike handles complex commercial litigation, representing both financial institutions and individual investment advisors in a wide range of matters involving securities and commodities, labor disputes, and trade secrets. One last item, if you have a question at any time during the webinar, please type it in the Q&A question box located in your Zoom control panel. We will address them at the end of the presentation or follow up with you afterwards directly if we run short of time. Now I will turn it over to Andy to begin our presentation.
Thank you very much, Amy, and good afternoon, friends. Thank you for joining us today. I'd like to start out with some breaking news, and it's something that one of my clients, when they got the invitation for this program, said, "Why are you putting this on? Aren't non-competes going to be illegal soon?" And I'll kind of give you a cheat. I don't think so, but certainly the Federal Trade Commission would like to do so. And let's talk about this proposed ban of all non-competes that was issued by the FTC on January 5. Number one, did this come as a surprise? Was this a shot out of the blue? No. Dating back to 2016, the Obama administration issued a white paper basically saying non-competes are bad for American business, bad for American employees, and the federal government should do something to outlaw them. Well, then, as labor issues are significantly impacted by the political fortunes, a different party, a different administration was in the White House, and no issues with non-competes and non-disclosure agreements. However, after the 2020 election, many of us and many business and sided groups were wary that this could happen. And indeed, President Biden in 2021 gave a speech in which he said non-competes are bad for America. And so, of course, the announcement on January 5 to ban all non-competes was not a surprise, although many of us were a bit surprised by the sweeping scope of the FTC's proposed rule. Now, the proposed rule will not become effective for at least 60 days after it was issued. The FTC is entertaining comments from interested parties, but let's talk a little bit about what would happen if the current form of the FTC's proposed rule would go into effect. It would ban all non-competes in any way related to a worker anywhere in the United States, and it would effectively federalize state contractual arrangements. There are lots of different rules and laws that limit or restrict or allow non-competes across the 50 states. This would essentially federalize that aspect of employee relations. In addition, it goes beyond just mere employees. The FTC's guidance talks about workers, and they specifically include independent contractors and sole proprietors. So this goes well beyond the employment relationship. Now, unlike many state laws, which have amended non-competes and gave a grandfather recognition to non-competes that were already in place, the FTC would require employers to rescind all existing non-competes at the peril of significant penalties if they don't tell employees, no more handcuffs, you're free to do as you please. Now, the FTC has not gone so far as to ban non-disclosure agreements, or sometimes called confidentiality agreements, non-solicitation restrictions that would prevent an employee from poaching their former coworkers or customers, in theory, would remain in place, but the FTC has said if it really functions like a non-compete, but it carries a different name, those are illegal as well. And I think many of us think that without some brakes that are put on by the courts, those will be the next targets if they get their way with non-competes. Now, there will be litigation, and I don't think I'm betraying any confidences to let you know that a number of leading US business organizations have been planning for this day and are prepared to challenge this rule vigorously. And I think we'll see the US Chamber leading the charge. They have been quite vocal in previous statements attempting to defend an employer and an employee's ability to freely agree to the conditions of their employment. There is one Supreme Court case, and I don't want to get too technical, but I'm only going to mention one case here, and that was West Virginia versus the EPA. And this was an important Supreme Court decision from 2022 in which the court effectively nullified an Obama administration clean air proposal that would have had sweeping consequences across a broad array of industries and would have stepped on the turf, if you will, of other federal regulatory bodies. This proposal, which was broad in scope, again, was nullified and rejected by the Supreme Court, and many commentators, myself included, think that this rule in its current form will likely suffer or experience the same outcome if it makes its way to the Supreme Court with the current composition of the court and assuming no changes on the court itself. Now, the day before the FTC issued this proposed ban, they announced that they had already been enforcing and prosecuting companies for abuses, alleged abuses of non-competes. And I'm going to give you the two examples that they mentioned in their January 4 announcement. The first involved a consent decree that was entered into by two security firms in the Philadelphia area that required fairly low-wage hourly paid security guards to sign non-competes. And not only did it contain standard injunction provisions, but it said they would have to pay a $100,000 penalty if they breached the terms of their non-compete. So the FTC cracked down on those companies and said this is an example of how non-competes can be used to abuse fairly low-paid, lower educated, less sophisticated employees. And in this case, we're using our authority to protect those less sophisticated, lower paid employees who have no meaningful leverage to negotiate with their employer. The second action was more complex, and it was filed against the two largest manufacturers of food, glass, and beverage containers, both based in the Ohio area. And as I understand the situation, and according to the FTC, they really dominated the market share in this sector. Now, these businesses didn't go so far as to require lower paid employees to sign non-competes, but pretty much any employee who knew about the business or was a manager or could help a competitor start a new business, they were subject to the non-competes. And so the FTC said, we challenged them because the non-competes were so broad and their dominance of the market was so significant that it was effectively anti-competitive. It prevented competitors from entering into this particular industry segment. And this kind of dovetails with some of the statements the FTC made. They said there are two main goals. The first and foremost of which is to protect lower paid workers who don't have leverage to negotiate their terms. But they also addressed highly paid senior executives making millions of dollars who may have graduate degrees and lots of years of business experience who do have leverage. And they said their non-competes are wrong because even though the people know what they're signing and can fairly walk away if they don't like it, it's still anti-competitive in that the presence of non-competes limits the mobility of labor and the formation of competitive companies. So those are the two stated policy drivers. Where do I think this will shake out ultimately? I think the FTC played its strongest hand, its most extreme hand, knowing that ultimately there will be a middle ground that is reached that may resemble some of the newer laws that we see in states like Illinois, Massachusetts, the state of Washington, that limit the use of non-competes, but allow them for employees above certain significant income thresholds. That's my prediction, but stay tuned to this space. There will be lots of activity. And now, Amy, we can go to the next slide. And we're going to talk about non-competes because I think our advice to clients is business as usual, keep calm and carry on until further notice. So let's take a look at what I think is a good best practices approach to using restrictive covenants. I am not a proponent of having hourly wage employees, low paid employees sign non-compete agreements. Even if you have them in a state that allows it, I don't think it's a good idea. I do think it's a good idea to follow the pyramid approach that you can see on this slide. And all employees, hourly, lower skill, should agree not to disclose confidential information or trade secrets. A low-wage employee may have access to very important confidential information that shouldn't be shared outside your company. You can also ask employees to assign any IP creations that are relevant to the business, and that should be done. That is done across the board for all employees, and you can even do that in states like California that prohibit the use of non-competes. And then let's go work our way up to the middle of the pyramid, non-solicitation covenants. These are good tools and useful tools to use, particularly for employees who are customer-facing, salespeople, people who might have the ability to be a Pied Piper. And if they leave, they can effectively poach employees from going to a competitor. And at the very top of the pyramid, it's often called the pyramidion, is non-competes. And my personal preference is that use non-competes only for those employees who are so strategic and so important that you couldn't afford to have them go to a competitor, even if they're not customer facing, even if they're not a charismatic Pied Piper who might take employees with them. And this more nuanced approach, if you will, can often, and Mike will talk about this, help your chances in court by showing we don't make everybody sign non-competes, Your Honor. Non-competes are strategic and reserved only for our most important employees. That's my preference. Some companies do otherwise, but that's the approach we take at Kelleher Holland. Amy, could you go to the next slide, please? I want to focus on the first bullet on this slide. And if there's one thing you take away from this, out of all the materials I'm talking about, remember this first bullet. look at your non-competes and see what the governing law states, because this has been a big change in the law over the last 10 years. Historically, if you were an Illinois-based company, for example, you could say this contract, this non-compete is governed by Illinois law, even if you're in California or Massachusetts or other states or Delaware. Increasingly, more and more states will say, we're not going to apply the law of a different state, because if the employee's primary place of work is in a different state, that's the law we're going to use to enforce agreements. And it's difficult today in the post-COVID world where companies are still trying to audit and find, where do we have remote workers? Employees can easily change their work location to their new home in a different state. I would consider looking at what I call a floating choice of law and forum, where the law that applies to a contract kind of changes as the employee's work location changes. And that allows you, with appropriate edits and appendices to the agreement, to always stay on top of the law. Because an employee who migrates from Ohio to California as their place of work is no longer subject to a non-compete. You can't make them go to a court outside of California to fight a labor dispute or litigate a non-compete. Also, because non-competes are getting tougher and tougher to enforce, consider other options, including for key employees, a slight variation of the employment at will concept that says both sides have to give, say, 30 or 60 days notice in advance of a termination. And that during that time, you can basically put the employee on home leave, or as they say in the UK, garden leave, where they can tend to their garden while on the payroll, and the employer can have an opportunity to get a head start against competition and put the succession plan in place. Even in states that don't like non-competes, California accepted, this may be enough to give you that head start if you have a non-compete that in its own right is not enforceable. And the other thing to consider, and it's expensive, but if you're reserving non-competes for those employees that you just can't lose, consider paying them a portion, or better yet, their base salary for each month they're sidelined. In some states, that is now a requirement. Look at Massachusetts in certain cases. But even where it's not required, if you can show the court the employee will suffer no loss in income while they're sidelined, that makes your case much stronger. Amy, let's go to the next slide if we can. It's important to have good reasons to defend having a non-compete. You can't just have a non-compete without showing the court, I've got something important to keep from a competitor that justifies the use of a non-compete. And those are called, in legal terms, a protectable interest. And a protectable interest can actually be a number of things, ranging from customer goodwill to certain R&D. But usually the most important and common factor is an employee's access to confidential information and trade secrets. That will allow a non-compete. If an employee will take trade secrets or confidential information to a competitor, you have a right to stop that and to prevent the employee from exploiting or using that confidential information and trade secrets. It's important, though, that you not just have a paper recitation, because Mike will talk more about this, and I'll give a little preview and spoiler that if you aren't walking the walk and actually treating your confidential information and trade secrets as secret with security controls, limited access, you're going to make the litigator's job much more difficult, and the odds of defending your agreement will reduce. Next slide, please. Another key concept from a state law concept is lots of people think I'm going to have a long non-compete. Maybe I'll overreach and use 3 years because a court will use its blue pencil and scale it down to 1 year if that's all that we can get. Increasingly, states won't do that. In many states, at best, a court will strike a provision and it won't rewrite it. And this may require what we call a waterfall clause, where if 12 months is too long, the term will be 9 months. And if 9 months is too long, it's 6 months. Now, I hate doing that. Companies hate doing that because it's basically saying, what's your bottom line? What's the minimum you'll take? Because courts go right to that bottom oftentimes. But some states, that's what you have to do. So be aware of where you are and what are the rules. Courts won't always help you by rewriting a contract. Next slide, please. The other thing that is important to put in an agreement are what I call offensive weapons, because you put this in the agreement, it makes the employer look reasonable. And in my experience, employees seldom follow through on these contractual options. First, you want to tell the employee you have to disclose your restrictions to any new employer. Now, that is generally lawful in almost every state. Second, the employee has to agree to disclose where did they go? What are they doing? You want to consent so that if you know that an employee is going to compete, you can send a lawyer's letter and say, by the way, this person has joined your company, we believe, and they are subject to certain restrictions under this agreement. Often without that provision, an employee could say, hey, you interfered with my employment with new employer. I'm going to come back and sue you for tortious interference. You want to have the employee agree that at any time they will certify under oath, yes, I am not competing. I have not taken trade secrets or confidential information. Based on past experience, employees aren't going to do that. And finally, create a lever in the contract that says our door is open, employee. If there's anything in this contract that you think might keep you from getting a job and that there might be a workaround, come and talk to us. We're not committing to change, but the door is open for a dialogue. Again, employees seldom do this. I could probably count on one hand over my 35 years where this happened. And by ignoring all of these procedures, when the employee leaves, all of a sudden they look like they've got what we call unclean hands. It looks a little sneaky and suspicious. Let's go to the next slide, please, Amy. A quick word on drafting non-US agreements. The bottom line, you can't use your US agreement anywhere outside the US as a practical matter. They need to be customized to align with local laws and rules. Even IP assignment terms are subject to different rules. You may have to pay people to capture their IP rights, even if they relate to the business. And there may be circumstances when a non-compete is simply not worth asking for, given the restrictions in local law. And with that, I'm going to turn things over to my colleague, Mike Lee, who will talk about how do you make these things work in court. Mike?
Thanks, Andy. So one of the fun things that I get to do is I get to go to court and either enforce an agreement that Andy wrote, or somebody who didn't listen to Andy's talk and makes the contract unreasonable, and I get to attack it and say, here are all the problems with the contract. So that's part of the fun of litigation. So I'm going to kind of, like most litigators, I'm going to talk out of both sides of my mouth. We're going to look at both when you are looking to, say, hire someone, right? Many of your companies, you grow organically, you hire individuals and you cultivate clients and you grow your books that way. But sometimes you want to grow your company inorganically and buy a book of business. And so we'll look at that in particular and look at it from both sides. So in my practice, I've been on both sides of that. I've been the offensive coordinator, if you will. And so I know what a defensive coordinator will do. and vice versa. I've been a defensive coordinator, so I have a pretty good idea of what the offensive coordinator's playbook is. And so that's what, between drafting our agreements and helping you bring clients over or chase them on an agreement, that's what we're looking to do here. So let's take a look first. Let's look at the hiring side, right? You're looking at an advisor. We'll just talk. We'll focus on financial services. As Amy mentioned at the beginning, I've done a lot of this litigation in the financial services, broker dealer, RIA world. I believe that there are a number of you on this call, so this may resonate. Some of you might bring back some bad memories if you were left a firm and you got TRO'd by your former employer. But this is kind of the steps and some of the ideas and the tricks that we start with, but quite frankly, we would develop a plan specific to your situation as the need arises. So let's look at the hiring side, right? So our first thing is, right, you're looking to buy someone with a book of business, and you want to maximize that hire and understand going in that there may be some litigation risk, right? The individual may be under an agreement. Maybe it's a well-written one that Andy put together, and so it's reasonable and such, or maybe it's, overreaching and such. So that's one of the first things that we're going to do is we're going to, as you have your recruiting person look at someone that you want to bring over, that's your first thought, right? So we think about the transition strategy. If you could turn to the next slide, right? We want to try and find some strategies, and there's no like absolute right, wrong. If you go this path, nothing's going to happen. If you go this path, everything will go wrong because it's litigation and you have to deal with the other side. So, we look at the different strategies, the different variables, how much risk, and as business people, the more risk you take, you might get the bigger reward. The less risk you take, the less reward, but that's part of your analysis. So if we could turn, right? So we start building a transition strategy, right? And these are things that you want to ask, right? Well, Mike, can he or she bring information? Well, I guess you can do anything you want, but as Andy mentioned, there is going to be an issue, perhaps, because there might be a confidential information provision, right? And in order to bring that information over, you may violate it, right? So actually, what's interesting on that, if I just quickly turn my hat on the other way, I was on a situation where we hired someone from a firm, and of course the other firm filed an application and jumped up and down about this information's confidential, and he signed an agreement, so on and so forth. One of the fun things we got to do as part of the litigation is we did a little dumpster diving, and we found a lot of the plaintiff's confidential information in the dumpster. That was a long time ago, right, when information was in paper form. But bringing that in front of the judge, it really made the judge look at the plaintiff and say, wait, you treat confidential information so confidential that you put it in the dumpster, and the judge denied the TRO application. So, these are some of the practical things that we look at as we work on a transition strategy. But with respect to information, there are other ways to get information, and these are things that, as part of your risk tolerance, do I want to have the individual bring stuff over, or is it available elsewhere? These are some of the things to think about with respect to client or confidential information. If you could turn the page, right? As part of that, not only the information, but it's about the customers, right? You're going to pay a sizable amount of money, perhaps, to this new recruit. You want him or her to bring the clients over. Can he or she contact them? Well, number one, we're going to look at the agreement. Is there a non-compete? Is there a non-solicit, right, that prohibits the individual from contacting them? If so, are you willing to take the risk to say, hey, I'll get the most bang for my buck by allowing the individual to contact them, and let the chips fall where they may if their hiring firm says, we're going to sue on that solicitation? Or are there other potential avenues that we could take that are a little bit more conservative, but perhaps can hide your individual in the weeds? So that's part of your transition strategy. The idea is, on the hiring side, you want to hide your individual in the weeds, right? going in eyes wide open. Is there an agreement? What are ways that we can work around, skirt around the issues that are raised in the agreement, that you can still have a successful transition and perhaps minimize that litigation risk. So that's one of the areas that we offer and we discuss as part of a transition when you're going to bring someone over. Quite frankly, preferably have that conversation before you hire the individual rather than after. So now I'm going to turn my head around and we're going to look at the other way. Now I'm representing the firm that just lost an individual, right? So it's Friday afternoon. And the best way I've always explained this, and it's starting to get dated, is if you remember the movie Jerry Maguire, when Tom Cruise leaves the office with the goldfish and they do the split screen on the television or on the movie, and you got Jay Moore calling people and you got Tom Cruise calling people, you know, that's what happens on a Friday afternoon in the financial services industry, right? Somebody resigns and they're looking to leave, they're leaving, and the firm is saying, now what do I do, right? So like first thing, as always, call your lawyer, right? What do I do? I just lost an employee. And as part of that, then we start putting in the steps to try and see what is he or she required to do under an agreement and what is he or she doing to violate the agreement, right? So simply call it human resources, right? Did the employee have an agreement? If so, okay, let's start looking into some of these things. You know, was confidential information taken? You know, I've got one of my fun war stories. The client lost an advisor, and we're in the advisor's former office looking around trying to figure out, are there documents missing or not, right? And then next thing you know, somebody's walking by the office, they realize that the advisor's gone, and they say, hey, where are the binders? And of course, everybody looks at her and says, what binders? You know, the advisor kept a whole bunch of binders that she knew of behind his desk on the credenza, which contained all the information about the clients, and they were missing. So, you know, it's things like that. Those are the types of investigations that you want to take, right? Next slide, please. You know, you also want to know, what is the advisor doing or the individual former employee doing? Violating by contacting clients directly, you know, as you call on clients and the clients say, oh yes, Mr. former employee was here. He came to our office, told us, or came to our home, told us about his new position, how great it was, and pulled some documents out of his briefcase and asked us to sign them there on the kitchen table, right? What are the types of conduct that the person is going through that arguably would violate the agreement? So as you gather that type of information, gather that type of evidence, you know, then the balls and the imaginations start happening. Do we want to seek a TRO? Can we file litigation to slow this person down? Do we send a demand letter saying, hey, here's your agreement. We know that you're doing this. Cease and desist, stop right now, and, you know, write back and affirm that you're going to stop. These are all some of the different strategies that can be employed on the enforcement side, right? And so that will, you know, play into the decision whether you want to file a lawsuit or not. And the litigation is always going to be interesting, right? Because, as you know, the judge has to hear both sides. The judge is going to hear, when I have my enforcement hat on, judge, the defendant signed an agreement. This is what the agreement says. And he or she is violating paragraphs 1, 3, and 4 by the following conduct. Here's affidavits. And of course, if you turn your head on the other way, the defendant's going to say, no, judge, that's not what I did. I didn't solicit. I just sent out a mailing, or I just put an ad in the newspaper. The clients contacted me. That's part of the tussle that goes on in these types of cases. So, you know, that's part of your machinations as to when, if you want to file. And if you could turn to the next page. And part of that, you hear a lot about in this industry seeking TROs, or immediate injunctive relief. You get a lot of bang for your buck if a TRO is entered, because you effectively put the defendant on the bench by court order. And hopefully in that time while he or she's on the bench, 15 days, 30 days, 6 months, whatever the judge will order, hopefully you are out there solidifying those relationships with your clients, so that when the defendant comes off the bench and calls those same customers, they're going to say, hey, Mr. Defendant, we haven't heard from you in a while. So in the meantime, we were talking with your former firm, and you know what? I think we're going to go with the newly assigned advisor who's on our account because he or she had some great ideas, came out and met with us, and we liked what he or she was saying. So it's all about, of course, keeping customers and using this as potentially a tactic for retaining clients. As part of that, we have, and it's always going to be a question with your lawyer. Also depends on what your agreement says. Do we want to go to federal court? We want to go to state court, or many times, especially if you're in the regulated industry, like the broker-dealer world, you have to go to arbitration before FINRA. So these are all the kind of the things that you need to consider and think about when we're in the litigation world. And then at the end of the day, if hopefully you get depending on which hat you're wearing, of course, if you're on the enforcement side, you get an injunctive order. And then the question is, what do you want to get out of this? These are all the questions. There's no straightforward flow chart as to what you want to do, but these are all things to consider. If you're the plaintiff and you've lost the employee, and then vice versa, trying to hide your individual in the weeds when you're on the hiring side. So that's kind of a real quick snapshot on the litigation process when we enforce and we defend these types of situations with restrictive covenant agreements. So remember, big picture, what do you want? It's in the intangibles, what do you want? Your ultimate objective, if you're on the hiring side, is to get the individual over cleanly and try to get as much of his or her book over without litigation. On the other side, you may think about litigation, and litigation may be a tactic to help you retain those clients. So that's kind of how these restrictive covenants and non-solicitation agreements work in the litigation and practical world as they intertwine with, as you develop them with your lawyer, such as Andy. All right. Yeah, I think Amy, we're kind of running low on time. So we do have the slide deck available for those, but perhaps if we have any questions, Amy, maybe now's the time to start fielding some of the questions from the participants. Amy, you're on mute.
There we go. We have time for some questions. We do have a couple that have come in. One is, we have employees in Canada. Can we use non-competes with them?
Mike, I'll jump in and take that one because I probably didn't, gave short shrift to my slide on non-competes outside the US. And obviously somebody here is concerned about Canada. I think I know why that question was asked. In the province of Ontario, last year, they effectively eliminated the use of non-competes for all but a very narrow tier of executive level employees with a specific corporate authority. And they did this after considerable debate. The legislative record, the history of the bill, if you will, is really fascinating reading, because the upshot, the driver of it all was Ontario has a thriving tech sector with great universities, the University of Waterloo, which produced BlackBerry and many other IT innovations. They felt that they were being tied up, and the ability of those university graduates to learn, work at a larger company, and then go work at a startup was limited because non-competes were enforceable. And they pointed to the US model in California, said the US IT sector is the leading sector in the world, and non-compete agreements, customer non-solicitation covenants, are not permissible in California. So Ontario has gone in that direction. I wouldn't be surprised if the other provinces follow. And I do think, in fairness to the FTC, they are really not taking an extreme position when you look at the big picture globally. the UK government over the last year and a half to 2 years has set up a commission to study what to do with non-competes in the UK. And generally in the UK, you could have non-competes. They're for shorter limits. Seldom do you see anything more than 1 year. Generally it's 6 months. But on the table in the UK is a range of options, from the California approach, as they call it, which is to eliminate all non-competes, because California seems to have done okay in terms of keeping, IT industries in that state, to the continental European model, where in many Latin American countries or many continental European countries, you can have non-competes, but you got to pay. And it may not be 100% of the employee's wages. It can be close, or maybe as low as 50 in some Southern European countries. But employers there need to put their money where their mouth is. And so it'll be interesting to see where the UK comes down, because frankly, the US legal system, certainly its embrace of the common law system, follows UK law. It's very much in the footsteps of our, the English founders of the country. So what happens in the UK could resonate in the US if the FTC doesn't get their way, or the matter is still, stuck in courts and no changes have been made at the federal level.
Just a reminder for anyone who has a question to type it in your Q&A box in your Zoom menu control panel. And we do have a few more questions popping up here. One question is, do we need to do anything now with employees who are subject to restrictive covenants?
You want to field that, Andy, or I can field that? I mean, Andy said at the beginning, right? We just stay the course. At least with respect to the FTC, you may want to revisit them depending on which state your company is in, to see if there had been any changes. Just as an example, we're here in Illinois, and the Freedom to Work Act was enacted and put into effect at January 1 of 2022. And so that may or may not have impact on some of your agreements. And so that may, if you're Illinois based, you may want to pull out some of your agreements and have them reviewed to see if they comport, or also on a going forward basis, how they may be impacted by Illinois law. I don't know, Andy, if you had any other thoughts.
Yeah, Mike, I fully agree with what you've said, and I'm just going to embellish with a few additional thoughts. First and foremost, you don't need to do anything right now, at least based on the FTC's proposed rules. So no need to change. But I think it's important to privately, and with the help of legal privilege, look at your use of non-competes. Because you may find, as Mike said, you have employees in a state where you can't have that, or you can't have a non-compete or restriction as it is in its current form. Second, even though the FTC, the rules aren't yet in effect, look at what happened to the security companies in Philadelphia, to the packaging companies in Ohio, where if you are perhaps being overly aggressive in your use of non-competes, the FTC is looking for situations they can exploit to make them look like the good guys here. And so in Illinois, Mike talked about our state's Freedom to Work Act. It's a statute that really has increasingly over time limited the use of non-competes with ever increasing income thresholds. What triggered that? A sandwich shop company had a policy of having their hourly assistant managers, who, according to the court records, their primary job was making sandwiches and maybe, doing some mild setup. They signed non-competes. And so that company and its practices became the poster child of, here's how poor, unskilled, low-paid workers are exploited from taking a higher job at the sandwich store 2 blocks down the street. And so, the same thing with the security company. You've got people making minimum wage as security guards, and, they're probably not highly educated. they know that if they try to get a better job for another security company, they could have to pay a $100,000 fine or penalty to their employer. So if you think if you're at potential risk of some embarrassing situation or a situation that somebody might view as extreme, you don't want the only people who will be happy if the FTC comes after you now for abuse will be your attorneys who will stay busy. Because even though you might be right, nobody wins when you're defending against the government in a situation like this, unless you have unlimited resources. And many larger companies do, but it's a difficult situation. So I think this is a good time. And maybe if you've got some people who shouldn't have non-competes with them, release them from their non-competes. It shows your ongoing efforts to kind of prune the garden and make sure we're only locking in our key people, not everybody. We're not being anti-competitive. We're not exploiting unsophisticated low-wage workers.
Great. We've got one other question that has popped up. Does offering a signing bonus of $500 to $1,000 for signing the non-solicit and non-compete agreement help to enforce these contracts if all other details are in legal compliance?
Mike, I'm happy to jump in if you want to go first.
No, I mean, I guess one of my questions would be, is that at the inception of the employment, or if it was given or at the individual asked to sign the agreement midstream, if you will, during the course of his or her employment? I guess it's going to depend whether it be $500, whether it be $1,000, whether it be $10 million, how the court will view whether or not that was sufficient consideration. That would be the argument. Let me put on my enforcement hat, right? If I'm prosecuting that judge, not only are the provisions reasonable and in compliance with, the state law, but in addition, the defendant individual received additional consideration separate and apart from employment or continued employment for signing the provision, for signing the agreement with the restrictive covenant. So that would be the argument. Of course, ultimately, it's up to the judge. He or she will make the decision if that's sufficient, but it does help bolster the argument in court that that there was consideration given, and that this person got something more than just employment or continued employment for signing the restrictive covenant agreement. That's the argument I'd like to make on the enforcement side with that.
Yeah, I'll jump in with a couple of thoughts, because I agree with everything you've said, Mike. I think it's important to look at, where are you located? Where is the employee located who's getting the $500 or $1,000 bonus? Because in some states, that's going to be really strong and powerful.
They're saying Illinois.
In Illinois,
Mm-hmm.
then I would say it's a closer call. And the reason why many companies do this in Illinois is historically, until really a few years ago, and there were some cases, I promised I'd only use one case, so I won't state them by name, but Mike can do that if he wants, or I'll do it if there's demand. But you could make an employee sign a non-compete at the front end, and just the offer of employment by itself was good enough to support a non-compete. Then there were cases that evolved that said, well, if the only thing the employee gets is a job, and they're employed at will, as most people are, and that employment doesn't last for 2 years, then it's not enough. If the employee keeps working for 2 years and a day, that's good consideration. And so we saw cases around the state where employees were quitting after 18 months, 15 months. And the court said, well, all you got was the offer of employment. And even though you quit, you didn't stay for 2 years. And so under, in response to that case law, and also under the new Freedom to Work Act, employers have been giving something of value. And the Freedom to Work Act embodies those decisions that says where the only promise or consideration for the non-compete is the offer of employment or continued employment there has to be at least a 2-year duration from the date of signing. But if you give something of value, and what is sufficient value, that could be good enough so we can unleash Mike to enforce that agreement. I think the more you give, the better. And I tell my clients, yeah, it may be a good idea to give some money, but how about a separate bonus, a retention bonus, or the ability, if you sign the non-compete, you'll be in X incentive program. If you don't sign, that incentive opportunity is not available. And also, any future raises you might get will be contingent on having the non-compete in place. So if you never want to raise, you can reject the non-compete. And we take the same approach for existing employees who might be promoted. If you're going to be promoted from hourly to manager and be more strategic, you've got to sign a non-compete, even though you remain employed, but you don't get the promotion and the raise in pay and the raise in prestige unless you sign the non-compete. Those are all things that go into an amorphous calculus that ultimately would be determined by a judge, not a jury, who's presiding over the dispute over whether it's a good non-compete, whether there's adequate consideration.
I think it's time to wrap up our Q&A portion of the presentation. Thanks everyone for being very active in the question portion, and thank you for attending today. Feel free to contact either of our speakers if you have any more questions, or if you would like a copy of our slide deck that contains additional information that was not presented today, contact us, and have a great rest of your day. Thank you.